Good afternoon. Welcome to the Appellate Division, First Department. We have some 5.5 hours of argument time that's been requested. So please bear that in mind as I call the calendar. Remember that we have your briefs, we have the record, and we're fully familiar with the facts of your cases. First case, People versus Dykeman Carter. 5-1 and 5, thank you. Hansen versus Shea. Do you wish to submit? I don't see. Are you appellant or respondent? Well, I prefer that you do what you wish, but if you're asking if we have any questions, I don't think we do. If you want to argue, I'll give you 2 minutes. S. Children? Submitted. Obando versus S. Biot? Again, do you want to argue? Thank you for submission. Whelan versus Gramercy Park? Did you want rebuttal or just 5 minutes? 2 minutes for rebuttal. Give you 5, 2, and 7. Dorset versus 285 Madison owner?
Requesting 10 and 2. Respondent requesting
5, 2, and 6. Schaefer versus May?
Appellant 9 and 3, please, Your Honor.
I'll give you 6 and 2 and 5. People versus Derek Neal?
Your Honor, that case is
Thank you. People versus State of New York versus Cohen?
for the appellant 6 and 2.
I beg your pardon? Okay. 6, 2, and 8. 373-381 Association versus Ideco Productions? 5, 2, I'll give you 5, 1, and 4. Thank you. Greenway Muse versus Liberty Insurance? Give you 5 and 2, 4, 4 and 1. Gardner versus the City of New York?
Appellant 4 and 2, please.
I beg your pardon?
Appellant 4 and 2, please.
4, 2, and 5. Endemic Bank versus Baroy is submitted. Gregory versus MTA is submitted. First case for argument is People versus Dykeman Center.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Daquan Carter. Before addressing the supplemental agency instruction, I want to briefly address the photo array issue. The question at the Wade hearing was whether the photo arrays unfairly singled out my client for identification. If one were to pick up the photo of my client's photo array and ask the question, which one of these photos doesn't belong, you would surely choose the photo of my client. And that's because my client's photo in the array was significantly different than the other photos.
Counsel, does it matter that the evidence, in the evidence, there was a video, and so the jury had the opportunity to see the video in conjunction with everything else? Does that change this at all?
Well, it doesn't go to the merits of whether it was an unfairly suggestive
Is it
photo
harmless,
array.
in other words, given,
Right,
the
Your Honor.
circumstances?
That is an additional question here. Since the only identification testimony came from the undercover officer who had made that photo array identification, it was not harmless. Yes, perhaps the jurors may have been able to glean that it might be my client in the video, but
Was it even an issue at trial? Was identity an issue at this trial?
it wasn't an issue at trial, Your Honor.
So then why isn't it harmless? If it wasn't even an issue, there was no contest
Because
on the video.
the undercover was permitted to identify my client in court. That's why it wasn't an issue at trial. Had the array been suppressed, there would have been an independent source hearing. Maybe the undercover would have been able to make that identification at trial, and maybe he wouldn't have. But without that independent source hearing, we don't know whether the undercover would have been permitted to make that identification. So that was the critical testimony that eliminated identification from the case.
Was any objection made to his identifying the defendant during trial?
Well, there was the court having ruled that the photo array was not unduly suggestive, there would not have been a basis to object. And that issue was resolved at the suppression hearing when the court ruled that it was not an unduly suggestive photo identification. So there would have been no basis for making that objection at trial.
And when you said that your client's photo would have stood out, is that because of the background?
Correct, Your Honor.
So is there any research on whether the background of a photo makes a difference in terms of how a photo array is interpreted?
I'm not aware of any research that has looked into that question, but the standard at a Wade hearing is whether whether the suspect was singled out for identification.
But couldn't you argue that the fillers were reasonably similar here?
The fillers were...
Except for the background. I understand the background is, but the photographs essentially were similar, no?
The fillers were well chosen. That's not the issue here. It's the background that essentially said, that directed the viewer to that photo.
Does the fact that the court said that the fillers were very, very close, does the fact that they were so close make the background more relevant? Because it is almost like because then it's makes it more difficult, I guess, to choose if you have fillers who are very close. And so then the background would be almost a suggestion or a pointing. And your position is that the detective on a previous occasion had picked out the right person, and the right person had a dark background. And so then they knew that there was a dark background here, or maybe not know, but there was the suggestion that that could be the right person.
Couldn't have said it better, Judge. I see my time is running out, so I'll save my argument as to the agency instruction for rebuttal.
Thank you.
Good afternoon, and may it please the court, David Gagne for the people. As my adversary concedes, the fillers in the array looked, in the words of the hearing court, very, very much like the defendant. And so
But then what does that do with the background, given what I just said? The fact that the fillers are so similar then makes it more challenging to determine who the right person is. As it should be, you should have them as similar as possible. But then varying the background and it happens to be that the background is darker, the correct person had the darker background in the same way that the previous photo, the correct person had the darker background. Doesn't that then raise an issue that is concerning?
No, Your Honor, for a couple of reasons. For one thing, defendant's background by itself did not make him stand out as opposed to the fillers. So there were 6 photos in the array. There were, in addition to defendant's background being a dark shade of gray, there were 2 other photos that also had dark shades of gray.
Well, look, we didn't have, unfortunately, the benefit of this photo array, but the description, I think taking from the briefs, was that there were varying shades of gray, and that the darkest background was on the defendant's photo. And the same was true for the previous photo array, varying shades with the darkest one being the co-defendant.
Yes, that's true, Your Honor, but the co-defendant's background is not material to the fairness of the defendant's array for a couple of reasons. For one, Mr. Breedlove's array was administered 4 days prior to the defendant's array. So it's not as if the undercover viewed them one right after the other. There was a substantial gap in time that attenuated any connection between the arrays.
How many days did you say? I'm
There
sorry.
were 4 days, Your Honor.
So 4 days, but this is not someone off the street. This is a trained police officer, right? This is a person with skill and training who maybe have put one of these together themselves. Am I right? This was a police officer?
This was
the
a police
undercover?
officer. Yes, Your Honor, that's correct. The other thing that I would note is that the testimony of Sergeant Valerio, the person who administered the array, was that there was no communication, there was no code between him and the undercover that would suggest that the color of the background had any significance when it came to identifying who the person was that was involved in this drug sale.
But there wouldn't have to be if there was already the darkest background already went to the correctly chosen person previously. The suggestion could be that the darkest background goes to the correct person in the next one.
Well, Your Honor,
Suggestion, that's the whole thing, that shouldn't be suggestive.
well, Your Honor, the testimony was that the undercover briefly looked at the array and made the identification of the defendant. And we know that the undercover was in close proximity to the defendant for long stretches of time, and they wouldn't have had any trouble identifying the defendant.
Your time is running out, so I want to ask you about the agency. The supplemental charge went to the subject primarily, did it not, of the benefit factor. What justified that being the focus of the supplemental charge?
Your Honor, Justice Mandelbaum's response to the jury note was not focused on the benefit factor for a couple of reasons. One, the court reread the initial instruction to the jury, which included the 6 example factors, both pro and con, and then it added language from the Court of Appeals that gave an overarching definition of what the agency defense is. So to that end, the court stated that an agent must be a mere extension of the buyer, and that an agent must not act out of any independent desire or inclination to promote the transaction. And that language is really getting at the distinction that the agency defense is trying to draw between people who sell drugs or help to sell drugs and people who are merely acquiring drugs on behalf of another person. Thank you. Unless there are any further questions, I ask that you affirm.
Thank you.
It's my understanding that the opposing counsel has provided copies of the array to the court. So if the court does not have them, let us know, and one or both of us will provide them to you.
We do not have them, as far as I know.
I mean, I have copies here, but I know that the prosecutor attempted to provide them to the court.
Okay, so, but you have no objection to us receiving these? Thank you.
As to the agency defense, one of the main points your brief makes is that it was directed towards the benefit factor. But when the judge gave the charge, and then over objection, but then the defense counsel was asked, do you have an objection to any specific aspect of the charge that's been given? There was no objection to anything specific.
Well, defense counsel said, don't give the charge. The CJI charge is the right charge to give. So to me, the court then deciding to give the charge,
But the jury asked for something further. And they asked for more than just being reread the original charge, which they had because they had been furnished with a copy of the charge.
well, the jury asked for, if I may complete my thought, the jury asked for a clearer definition of the agency and agency defense. The Criminal Jury Instructions Committee has provided the clearest instruction possible, injecting other elements into the offense, into the instruction from Court of Appeals cases, which are not intended as jury instructions, they're intended as statements of...
But to that point, did the supplemental charge correctly state the law?
It correctly stated cherry-picked elements of the law, which all favored a finding that my client was not an agent. They were all stated as mandatory requirements. If there's a profit motive, you can't be an agent. If you're a middleman, you can't be an agent. There are all these elements that single out, that essentially preclude the defense that was being raised here, where in contrast to that, the CJI instruction is balanced. It provides six factors that favor a finding of agency and 6 factors that favor a finding of no agency, and to inject 4 additional lines from Court of Appeals cases, which all are negative to my client's defense, was unbalanced. Thank you.
Just a moment, just
I have
of
one more
course.
question about the photo array now that
Yes.
we've seen it. In looking at the photo array from which defendant was chosen, which I assume is the one dated August 23, 2016.
Right, correct.
It seems to me that as striking as the fact that the defendant in, the person in slot number 4 has a dark background, it seems to me equally striking that the person in slot 6 has a very light background. So I'm not sure how one can infer from that that the darkness of one background would single him out as opposed to the lightness of the background for the gentleman in number 6.
Well, the prior photo array, the co-defendant had the dark background. This photo array, my client had the dark background. And I would suggest that there are various shades of light backgrounds there. Obviously, there's always going to be a lightest background in a group of differing backgrounds. In contrast, there's only one dark background, and if you look at the sort of the contrast between my client and that background, it's very hard to just even see my client against that darker background.
Sorry. Oh, I thought there were more. Sorry, I thought there was more than one.
If there's nothing else.
Just one moment.
Sure.
Well, we have a moment, sir. Are you familiar with a decision from this court from a group of our predecessors from 1991, People versus Floyd?
Not off the top of my head, Your Honor.
Okay. The central holding, as I read People versus Floyd, was that the mere fact that there is a, quote, distinctively darker background, end quote, does not compel the conclusion that a photo array was unduly suggestive.
Right, certainly, Your Honor, there are cases to that effect. I don't think Floyd is even the only one of them. But you have to take each identification procedure on its own facts. I don't know how much darker the array, the background was in that case. I can't compare it. You just have to look at the totality of the circumstances. And in addition to that fact, you have 2 sequential photo arrays here.
Thank you both.
Thank you.
Hansen versus Shea.
May it please the court, Susan Paulson on behalf of the appellants. Thank you very much, Your Honors, for permitting me 2 minutes to argue. Your Honors, the Supreme Court erred in concluding that the petitioner was entitled to World Trade Center accidental death benefits as a matter of law. There's no question that Mr. Hansen's service was heroic, but the police pension fund was constrained by the limits of the law that the legislature enacted. And the World Trade Center disability law states that to be eligible for the presumption contained therein.
There is this finding from the NMS labs that there is antimony in defendant's fluid and brain tissue. Was that ever addressed?
Your Honor, the medical board did not specifically articulate any manner in which it was addressed, nor did the petitioner's doctors. It was presented, and I think it's a reasonable inference, but we don't know for certain that the medical board.
I guess that's the question.
Well, Your Honor, to the extent that this court believes that there's evidence that the medical board didn't address, the court could remand to the medical board to address it. But most importantly, what the World Trade Center disability law states is that to be eligible for the presumption, the applicants must have shown they had a qualifying condition, and that condition caused their death. So even to the extent that we were to believe that the toxicology report indicated that Mr. Hansen had heavy metal poisoning, and there's nothing in the record that contains such a diagnosis, but even if we were to assume that, there's absolutely nothing that suggests that heavy metal poisoning was the cause of his death. To the contrary, the cause of his death was pardon me for using the common name, Lou Gehrig's disease. And both the death certificate at page 42, the autopsy report at page 44 through 59,
Well,
and the death certificate.
with regard to Lou Gehrig's disease, isn't that a respiratory disease or a musculoskeletal and respiratory disease? And don't those both come under the World Trade Center condition?
Your Honor, initially, to start with, that argument was never presented either to the medical board or to Supreme Court, so isn't properly before this court. But even if it were, all of the articles in medical literature describing Lou Gehrig's disease describe it as a neurodegenerative disease, a disease of the motor neuron system. It absolutely affects the muscular system, and like many other things, it ultimately causes respiratory failure at the end. But it is not, as this court saw analyzed in Stavropoulos, when it was looking at whether or not pulmonary hypertension was a respiratory disease, it's never been considered merely because it has an effect. It may cause respiratory failure at the end of its progression, does not make it such a disease. But
The question? Go,
Yeah.
yes.
yes, Your Honor.
So I'm curious whether, given that it has a respiratory effect, whether decedent's exposure to conditions which affected his respiratory system might have hastened his death from ALS because of his weakened respiratory system.
Your Honor, there's nothing in the record that connects that. If he died from ALS, there's
I understand that, but he died from, but the way he died from ALS was because of its effect on his respiratory system. And if his respiratory system was weakened, damaged, et cetera, by his exposure to the World Trade Center conditions, could that have had an impact on the timing or, of his death?
Your Honor, I'm not a medical doctor. None of the medical records in here indicate that.
But didn't Dr. Hirsch, I'm sorry, didn't Dr. Hirsch say that the toxic exposure suffered by the decedent impacted on his health and neurological decline? So presumably there is a correlation between the two, right?
What Dr. Hirsch said was
And that's a finding or an opinion that the medical board doesn't address.
no, the medical board did address Dr. Hirsch's letter quite.
With respect to the toxicology exposure and the neurological decline as a result of that exposure.
I'm sorry, Your Honor, I might have missed part of the question. Dr. Hirsch did not address the toxicology report in any way.
Okay.
Dr. Hirsch said that he had a feeling that there was some causality between Mr. Hansen's illness and his exposure to the World Trade Center site toxins. He did not
address. Again, I know we started with, but does the record support saying you've got this NMS lab report, which shows the antimony and heavy metal poisoning has become a recognized onset disease, and therefore there's enough in the record to warrant that the medical board should weigh in on whether that could be the cause of the death. Why isn't there enough in the record to support that approach?
Your Honor, to the extent that the court believes the medical board didn't consider the toxicology report, certainly a remand would be appropriate. But nobody has connected the toxicology report, nobody has connected antimony, elevated antimony levels to ALS, or the results of the toxicology report to his death from ALS. In order to be eligible...
But it is connected to heavy metal. It is connected to that. The toxicology report
Correct.
does suggest, does it not, that possibility?
So there would need to, in order to be eligible, there would need to be a connection, but yes, Your Honor, let's assume for the sake of argument that the toxicology report were to indicate that he had heavy metal poisoning, although there is no such diagnosis in the record, but let's assume that for the sake of argument. That diagnosis would have to be the cause of death in order to be eligible for the World Trade Center disability law presumption, and that link is not drawn by anything in the record. As this
Could there be concurrent causes?
Sure, but again, it still has to be identified. As this court recognized in Stavropoulos and Hayden and Fessler, to the extent that the petitioner is trying to establish that perhaps ALS could fall under a new onset category and be connected to heavy metal poisoning, the burden was on the petitioner to demonstrate by credible evidence a connection between World Trade Center exposure and ALS, and this she failed to do. She didn't present, there were no medical studies linking ALS and World Trade Center exposure or epidemiological evidence of disproportionate numbers of individuals with ALS.
Counsel, I have a further question, which is that in the other cases finding new onset diseases, it appeared to me that one characteristic of those diseases is that they're idiopathic, that is, that their causation was not known, which I gather is also true of ALS. So wouldn't that be a factor that should be considered in terms of whether it should be considered as a new onset disease?
Well, I'm not sure that all of the new onset conditions are idiopathic, and certainly...
I'm not saying that all are, but at least some
Okay.
were.
It certainly could be a factor that's conditioned, but it's still, the pension fund can't administer the statute based on speculation. They still need objective guidelines, and this is what this court established in Stavropoulos and Hayden and Fessler by saying that there has to be some credible evidence. And all we have here is conjecture and speculation. We have two of his doctors, one saying it's possible that there's a connection, and another saying that the individual had a feeling that there might be a connection. Neither of them pointed to any medical or scientific literature drawing such a connection, and none of them discussed antimony, a connection between antimony and ALS, let alone indicated that they believed that he had heavy metal poisoning or that it was causally related to his death.
Thank you.
Thank you very much, Your Honors.
Whelan versus Gramercy Park.
May it please the court, my name is Daniel Fox. I'm with the firm Lewis, Brisbois, Biscard, and Smith. I'm honored to be here this afternoon. I thank you for the time.
Of course. So let me ask you
Please.
this question about the statute of limitations here. And why aren't these claims governed by the 6-year statute of limitations, since they all seem to arise out of the lease, which is a contract?
Well, first and foremost, these claims arise out of, well, they're property damage and personal injury claims that arise out of the exposure to a substance, which is governed by 214C. None of the cases that are cited by the plaintiff or by the trial court address this particular nuance.
Well, let's take this let's take the personal injury out of it for a moment. It's still, what remains are contract issues. Breach of contract, the breach of fiduciary duty, the warranty of habitability that pertains to the lease.
We certainly do not dispute that there was a lease agreement that governed the relationship between the
But I'm
parties.
speaking directly to the 6-year versus the 3-year. I mean, why are they limited to just the 3-year? Why can't they choose which course to take? And why isn't it proper to pursue a 6 years under the breach of contract?
For one thing, we would point to controlling precedent from the First Department in the Davis versus St. Joseph's Children's Hospital case, in which the court held that the choice of the applicable statute of limitations is properly related to the remedy.
I think that case, I might be wrong, but I think that that's one that was where the tort was brought with it. I mean, if it was just the breach of contract cases and not the tort.
The court is correct. That was a personal injury only case, but that decision has never been distinguished, and it's still.
It doesn't seem like the 3-year limitation period of 214C supplants the 6-year limitation period if a plaintiff otherwise is entitled to the 6-year statute of limitations.
Your Honor, the
I mean, isn't the point of 214C to extend the statute of limitations for a plaintiff who would otherwise be barred by the statute of limitations? But if from the outset the plaintiff has a 6-year statute of limitations, it doesn't seem like 214C takes that away. So why, as to property damage, and what does property damage mean here, why wouldn't there be a 6-year statute of limitations?
The reason being is that 214C supersedes that statute. It controls because this is a case that specifically and solely involves latent defects based on an exposure to a toxic substance. In this case, it's alleged toxic.
Except if 214C applies to latent defects, and one of the things about the condition here is that it wasn't latent, it was visible from the very beginning. So I don't really see why 214C would apply at all, in addition to the fact that the cause of action specifically pleads breach of the proprietary lease and breach of the warranty of habitability, which are certainly contract-based claims.
The latency.
In counts 1 and 2.
Understood, Your Honor. The latency refers to the fact that the plaintiff was complaining about this condition in his apartment since 2006 when the unit was purchased, and ostensibly it took more than 10 years to diagnose what the alleged condition was, and ultimately.
So in your view, I guess the black soot is a patent condition, is a latent condition. Is that correct?
It is, Your Honor, because it was not diagnosed as.
Isn't it all over the walls?
You're confusing diagnosis with, observation. It was there. It may not have known where it was coming from, but it was there. It wasn't hidden.
I understand that, Your Honor, but the allegations as pled in the complaint seek recovery of personal injuries because of exposure to this toxic substance.
But we're not talking about recovery of personal injuries. We're talking about property damage claims, whether they arise out of a 6-year statute of limitations alleging breach of proprietary lease, or a 3-year statute of limitations, which you say 214C.
I respect that nuance, Your Honor, but what I'm mainly speaking about here is the fact that the plaintiff is seeking to recover personal injuries in this lawsuit.
My view of the order is that those claims were dismissed. I mean, that's my view of it.
They're definitely not dismissed, Your Honor.
Well, let's assume they are dismissed. Then the remaining claims, what would you say about the statute of limitations with regard to the remaining claims?
We believe, first and foremost, that the personal injury claims should be dismissed in their entirety.
Okay, so I just said, let's assume that they are dismissed. What would you have to say about the remaining claims, the remaining property damage?
We would say that Section 214C contains no limitation.
Well, suppose we don't agree. We didn't agree with. Let's suppose, for purposes of argument, we don't agree with what you're saying about that. Isn't what you have here? The claim here is that the proprietary lease required you to keep things in order. and you breach that duty, don't you have a continuing breach here in that this is a continuation of this suit condition, which you don't remedy, so the statute of limitations is 6 years from whenever a claim is made that you should do something about it and you don't. And the property damage is not, you could not recover a tort-like property damage because then the statute of limitations would accrue at the time that you become aware of the condition, which was years before. Clearly, that would be barred by the statute of limitations. But there's a diminishment in the value of this apartment because of your breach of the proprietary lease. If that's proved, isn't that something which can be recovered? And doesn't the right to that recovery continue? It's a continuing breach of the lease on the part of the defendant.
I believe that diminution of value of the property is not a measure of damage that is being sought by this plaintiff. At least it's not alleged in the pleadings or in the bill of particulars. With respect to damages that specifically flow from the breach of proprietary lease, we are not seeking dismissal of the entire cause of action. We are seeking dismissal of measures of damages, particularly personal injuries, that are time barred by virtue of CPLR 214C.
Thank you.
Good afternoon, Your Honors. Rich Trotter of Forrestine Kulik on behalf of the respondent, Mr. Timothy Whalen. I won't belabor the point because I think the court has hit the nail right on the head in a number of...
So putting aside personal injury, what are the contract damages that you say you're entitled to recover for breach of proprietary lease?
Absolutely, Your Honor. So we addressed this in our papers. I think the most concise explanation of the pecuniary harm and property damages that Mr. Whalen suffered can be found in the record at page 84 in the demand letter that he sent to defendants in 2018, which itemized line item by line item approximately $270,000 in pecuniary harm he had suffered to that point.
Where was that in the record again?
I believe it was record page 84, if I remember correctly. It was the September 2018 demand letter sent on behalf of Mr. Whalen to the defendants. And there are also pictures.
Well, when did you cause of, I mean, usually when we speak of statute of limitations, we speak about when the cause of action accrued. When did your cause of action accrue?
Your Honor, I believe the IAS court determined that the causes of action accrued sometime in 2016. The question of accrual is not really relevant to the IAS court's determination in this case because...
Why is 2016 the year of accrual? The suit condition had been appearing for a decade before.
Well, Your Honor, the answer to that is it took years. This actually goes to Mr. Whalen's pecuniary harm as well. It took a years-long investigation on Mr. Whalen's part, hiring engineers, architects, or environmental engineers and the like, to finally determine in 2018 that the cause of the soot in the apartment was the boiler room, which lacked adequate ventilation.
Aren't you making an argument then that this is a 214C situation, that this was a latent defect?
No, Your Honor, because as the court pointed out in some of its questions, there is a proprietary lease here, and the case law in this area, particularly the case law from the First Department, is clear that where there is a breach of contract and there are pecuniary losses in the form of property damage that arise directly from the breach, that is a free...
But if your claim is for tort-like damages, when did the cause of action accrue for tort-like damages?
Well, Your Honor, I think one of your fellow judges made this point, that there was a negligence claim that was asserted for the tort-like damages, the personal injuries. That was dismissed by the IAS court below, and that is not the subject of this appeal. What's left is breach of contract claim for pecuniary harm. And Mr. Whalen...
So presumably, you would be entitled to, you brought the case roughly in 2018, so 6 years prior to that are the damages you're seeking? Or even more?
Well, the pecuniary harm is certainly at least not less than the line item.
It should be limited to the 6 years before the time the lawsuit was commenced.
Would Mr. Whalen be limited to the 6 years prior to the commencement of the proceedings?
2018.
I'm not necessarily sure that would be the case, Your Honor, because, again, I think a critical part of this is the fact that the
On
breaches...
what theory could he be entitled to damages for more than 6 years back?
I didn't mean necessarily from prior to 6 years. What I meant is the damages are continuing to accrue because the condition that the defective boiler and the
But
failure...
that's a different point. That's a different
Okay.
point. We're trying to figure out what's the back end of it.
Yes, I believe then you're right, Your Honor. It would be 6
So
years.
you're
from now.
conceding that you're entitled to damages from 2012 to 2018. I know your adversary disagrees with that, but that's, and going forward, correct?
I think, Your Honor, the quantum of the damages specifically was not really the subject of the IAS court's determination, right? That is a
But
subject...
I'm asking you, well, what's the period that you're seeking damages from? 2012 forward or something different?
Well, I believe it's from approximately the period captured by the demand letter that I referenced earlier, which is itemizes as of September 2018 when the demand was made on the board after the cause of the soot was finally
Are you seeking damages, say, for example, from what occurred in 2010?
No, I don't believe we are, Your Honor.
Just 2012 forward, correct?
I believe that's right, yes.
Thank you.
And Mr. Whalen suffered significant pecuniary harm, and just to address the 214C argument, which opposing counsel raised, there is no precedent whatsoever for applying 214C to shorten the statute of limitations for an otherwise viable breach and timely breach of contract claim. In fact, the Court of Appeals in the Germantown decision, which is referenced in our papers, made very clear that the legislative purpose behind 214C was to extend, not shorten, extend the statute of limitations for a very specific type of tort claim, because plaintiffs who had been subject to the latent effects of a toxic substance were being unfairly prejudiced by the statute of limitations.
Well, because oftentimes,
Go ahead.
oftentimes too, in the toxic tort realm, there's no contractual relationship between the tortfeasor and the injured party.
Yes, that's correct, Your Honor. The existence of the contract, the proprietary lease in this action, is one of the distinguishing factors of this case, and one of the points that appellants' arguments either ignore or miss. There are, in fact, other cases involving harsh conditions and toxic substances where there's a breach of a proprietary lease, pecuniary harm, damage to property, and that is its own freestanding claim, which 214C has no application to. In fact, the lead clause of Section 214C makes clear, it says, notwithstanding Section 214, then this is what happens with latent tort claims, right, 3 years from discovery. Appellants consistently ignore or omit that language from 214C because it makes clear the limited application of 214C, and that it has no application to otherwise timely, viable breach of contract claims for pecuniary harm and damage to property.
Counsel, following up on Justice Singh's question, am I correct that you're limiting your client's damages to that which is set out in the expense chart at page 84 and 85 of the record, which, as far as I can tell, begin in 2013?
Your Honor, I would say it differently. Mr. Whalen's damages, that is, the demand letter is a snapshot of Mr. Whalen's damages as of September of 2018.
Right, but if those seem to begin in 2013, does that reflect your position that you're not seeking damages for anything earlier than what's in Exhibit A on pages 84 and 85 of the record?
Yes, that's correct, Your Honor. That is the damages that began to accrue when this condition started to inflict significant damage. And as the court will see from some of the pictures that are included in the record at page, I believe it's 115 through 120, you know, the damage, once the damage began to appear, it was substantial. It was not subtle. And Mr. Whalen was forced to remediate that damage through a variety of out-of-pocket expenses, and there was a substantial diminution in the value of his apartment, as well as its expensive
Your
contents.
adversary says you didn't raise that. Is that correct?
That he didn't, I'm
That
sorry.
you did not raise diminution of value of the apartment.
That's actually
just wanna
absolutely
ask
not
him
true, Your Honor. Both in the complaint and in the discovery, the bill of particulars that followed, there's ample allegations and evidence of a multi-million-dollar apartment looking, I believe the exact language is, like the inside of a chimney. To say that that did not result in a diminution of value to the apartment in Manhattan real estate, no less, I mean, I don't see how you can possibly make that claim. It's just that appellants prefer not to acknowledge the existence of the contract damages because they would very much like the contract claim to go away. But that's just not how New York law, what New York law holds, and it's certainly, there's no support for that in either the language or or the legislative history of CPLR 214, which I think it's worth underscoring here in my final point, has never been applied in the way that appellants are suggesting. They are unable to cite a single case in the 35-plus years since 214C has been enacted that has applied it in the way that they are suggesting, which is shorten the statute of limitations.
With regard to the statute of limitations, you're not seeking any damages beyond the 6 years. This amount on page 84 is less than the 6 years, but you are not going beyond the 6 years. It may be some other place within the 6 years.
Yes, or it would have continued to accrue.
Accruing damage.
Accruing,
Right, continuing to accrue.
I understand going forward. I'm not speaking about that. I'm talking about going backwards. This was till 2013, 6 years would be till 2012.
Yes, Your Honor, the pecuniary harm and damage to property that Mr. Whalen knew of as of 2018 is reflected in that demand letter. Those damages continued to accrue, and in fact, to this day, the boiler room condition has not been ameliorated.
I understand that. I was specifically asking with regard to time, that 1 year prior to 2013. Thank you.
Thank you. Thank you, Your Honor.
Thank you, Your Honors. Just a couple of quick points. The first thing I want to mention is that the court had inquired earlier whether personal injuries were already dismissed by the IAS court. In fact, they were dismissed, but exclusively within the breach of warranty of habitability cause of action. I believe that's page 33 of the record. And the crux of this appeal is seeking the dismissal of plaintiff's personal injury claims in their entirety, regardless of what cause of action they may be cloaked within. And again, we point out that the Davis decision and the Graboy decision, which is decided in our papers, both of which say that even when there is a contractual relationship between the parties, the statute of limitations that is applicable relates to the remedy, not the theory of liability.
Thank you.
Thank you.
Thank you both. Dorset versus 285 Madison owner.
Good afternoon, Your Honors. May it please the
Afternoon.
Court. My name is Jason Myers. I'm from London Fisher, and I represent the appellants in this matter. We're here today to address the contractual interpretation of a construction subcontract and whether the respondents had a duty to defend, insure, and indemnify the appellants.
I'm
The
not
appellant's
sure the
position-
question is the construction of it. I think the question is the authentication of it.
Your Honor, as to the authentication issues, it's been our position that the deposition testimony that was submitted in support of summary judgment authenticated each one of the prime construction contracts as well as the operative subcontract in this case.
Except the problem is that it seemed to me that as to each document, there was a piece missing between the deposition testimony and the document attached to your summary judgment papers. That in some instances, the person speaking had described a document but didn't identify it by a exhibit number, and there was no exhibit number on the document introduced on the motion for summary judgment, or it wasn't specific enough. So it seems to me there's a
There was
linkage
stickers
problem.
missing
Right.
from documents so that you couldn't relate it back to whatever it referred to in the deposition.
There's various deposition testimony that was provided by both Panava's representative and...
Right, we know there was deposition testimony, but the question is whether it was established that that person had knowledge of the relevant contract, and whether that person at the deposition identified a contract which was identical to the one which was then attached to the summary judgment papers. And it appears to me that as to each of these each of these essential documents, there was a gap as to each of, with regard to that sequence.
Respectfully, Your Honor, Mr. Grisili, who is the project manager of Panava, did testify, which is in the record on the appendix, page 755, that the two-page document presented was the entire subcontract. That was the Penguin Panava subcontract. And Daniel Pergola, the project manager of Penguin, testified on pages 870 and 871 of the appendix that he personally prepared and signed the subcontract, that he was given the information as to what the scope of work was and had an understanding of that contract. So there was testimony from both sides of the equation here, Panava and Penguin, that authenticated the subcontract.
Sir, in your underlying motion submission, which witnesses' deposition transcripts did you include in that, the record supporting that motion?
Your Honor, there was a significant amount of deposition transcripts, but I just want to refer to the appendix of my, the index of my, the table of contents of my appendix here. We attached the deposition testimony of plaintiff Michael Dorsett, Jerry Demanchik, Peter Grazilli, Dan Pergola, Stephen Paravolikis, Jake Swiggett, and then plaintiff annexed, sorry, not plaintiff, Panava annexed the deposition testimony of Jim DeLaurentis.
Thank you.
So the record contains the Penguin Panava subcontract at page 382, 383, which, the result of which would be that this would all flow to Panava. No one questions, do they? I mean, this was authenticated, was it not?
It is our position that it has been authenticated, and I believe the...
It's a signed agreement. There was testimony that this was the agreement, was there not?
Correct. Yes, there is, Your Honor.
And no one has suggested that there's any other agreement between Penguin and Panava than this agreement that appears at 382 and 383 of the record?
No, there has not been any other suggestion, Your Honor.
But you didn't present that on your prima facie case.
Our position, Your Honor, through the prima facie was that there is this...
That document was not, you had the document. Didn't you have that document?
The subcontract's an exhibit to the motion, Your Honor, our underlying motion.
It was part of Myers, that was part of Myers' affirmation. It was an exhibit to Myers' affirmation.
Correct, yes. And attaching supporting documents to an attorney affirmation is permitted. It's been permitted through the case law. Those documents were authenticated by the deposition testimony that was submitted with an affirmation. There's been no indication from the evidence and the record that there was any other contracts that existed other than this particular contract that's in dispute.
Thank you.
Thank you, Your Honor.
May it please the court, John Fabiani for the respondent, Panava. I think that the failure of proof in the record here is glaring. And Judge Higgett, I believe, asked a question about what depositions were attached, and there were a lot of depositions attached. What's glaringly missing from those depositions, however, are questions that are directed to the appropriate documents and to their interpretation, what exactly they meant. Even going beyond the issue of whether the Panava contract was subcontract was a.
Fabian, let's assume for argument's sake that the document, that the various contracts were authenticated. Did the defendants in any event make out a prima facie case for contractual indemnification here?
No, they did not.
Why is that, sir?
Because the contract itself identifies categories of indemnities, not specifically named entities. Getting back to what I was saying about the depositions, it would have been very, very simple for someone to have asked a Panava witness, okay, this document says you're obligated to indemnify the owner. What was your understanding of who the owner was? Nobody ever asked the question. So that's where the failure of proof is. The same question with regard to the contractor, the same question with regard to the tenant, whether there was or was not a tenant. Somebody should have asked those questions, gotten answers, and then would or would not have been able to make out a prima facie showing of entitlement at the motion.
Did the defendants show that they were free from negligence? I mean, it's just.
Oh, absolutely.
Even assuming, I disagree with you on the contractual aspects of it. Did they make that showing?
Absolutely not. I'll point to the record citations that show that the owner and Structure Tone were aware of the presence of the plank, were aware that it was being used improperly. This is a mixed means and methods and premises condition case. It's not purely a means and methods case because the plank that was being used was there before Panava's work started. But if you look at the record pages 1315 through 1319, you look at the record page at 656, the testimony of Mr. Domanchik at 656, 657, 658, 660, 677, and 773. All implicate Structure Tone and the owner in responsibility for the plank being there and for it being used as a means of ingress and egress. Not that I want to make out the plaintiff's case for him, far be it from me to do that. But in terms of what parties would bear responsibility if indeed it was a dangerous condition, there's ample evidence that Structure Tone and 285 Madison either knew or should have known of the existence. I think that there is one thing that the documents, when looked at in their entirety, make perfectly clear, and that is that the documents are anything but clear. And I think it would take a conclave of Talmudic scholars to try to reach the conclusion that that Structure Tone asks, when it would have been very, very simple, had they sought to do so, to have asked specifically, what did these terms mean? What was your understanding? Finding out the answers. If the answers were satisfactory to them, then they would have been able to move for summary judgment, and it would have been able to be granted. Having failed to do that, they failed to make out a prima facie case. So unless anyone has any other questions.
Do we give contractual provisions relating to indemnity broad readings or narrow readings?
They're against the common law. They're narrow readings.
So on page 383 of the record in the Penguin-Paneva subcontract, why does it mean subdivision 5? And I got to tell you, the print on this is about as small as the letters can be.
I hear you loud and clear. I can't make it any bigger.
To the fullest extent permitted by applicable law, subcontractors shall defend, indemnify, and hold Penguin, the owner, tenant, and general contractor, and the agents and employees of the foregoing, harmless of and from any claims, etc. What does that mean?
That means, well, the fullest extent of the law is, in order to comply with general obligations law 5-322.1, carving out the negligence of the putative indemnity. And what does it mean? Your Honor, if that question had been asked at a deposition, we wouldn't be here today. But the question was never asked. What does it mean?
But isn't that something that we could look at and surmise or determine for ourselves what that means?
I think that's stretching it, Your Honor. I mean, you can. I just don't think it would be appropriate for you to do so based upon this particular record.
Well, we have the first obligation of construing and giving effect to clear contractual language. So what in the passage that Justice Friedman just read was not or contained any ambiguity?
Well, there's no identification of who the owner is. Often the owner is the owner of the property, the owner of the project, the owner can be the tenant if a tenant is the one that contracted for the work. So owner can be subject to many definitions. Tenant, I don't think there's any suggestion that there's a tenant involved here, so I don't know who the tenant is. And general contractor is, there's a dispute as to whether Structure Tone is a general contractor or construction manager. Structure Tone has taken the position in response to the plaintiff's allegations that it's a construction manager, but in connection with its allegations against Panava, it's taking the position that it's a general contractor. Can't have it both ways unless there's clarification. Unless someone to have asked the question, who did you understand that to be? And if
Thank you.
Thank you.
Your Honors, to briefly address 2 points made by my colleague. Although the subcontract lists categories of owner and general contractor and agents, the trial court referenced that there are several related agreements to the Penguins and Panava subcontract that identify who those people are. And the focus of our appeal is the incorporation of those prime contracts. The prime contracts directly identify 285 Madison as the owner, RFR Realty as the managing agent, and Structure Tone as the construction manager who acted as the general contractor. And
Well, but doesn't it dispute that it was acting as the general contractor?
no, Your Honor, because the Court of Appeals has held in the Walls case that the title of the contract as construction manager versus general contractor is not what determines the role of that party. You have to look at the scope of the work. You have to look at their duties, their obligations, and they had the ability to hire and fire
Was that fleshed
subcontractors.
out at the deposition? Were those kinds of questions asked at the deposition to establish, in fact, that this is it's a GC and not a manager?
Your Honor, to go to that point and to also address as a point raised by counsel as to questions being asked and whether they're answered, they were clearly questions that were asked and answered and known because the record through the certificates of insurance show that Panava purchased 2 separate certificates of insurance, one to 285 Madison and one to Structure Tone for this project that lists every single party as an additional assured in which they were required to do. So they clearly knew prior to the start of this project who the owner was, who the general contractor was, and who the agents were because those parties were listed in the prime contract.
Can you
Are you
address?
suggesting that we can go backwards and say that from the insurance that they purchased, we can infer what the contract said?
No, Your Honor. No, Your Honor. The contract here, and I believe it's paragraph 4 of the subcontract, required Panava to purchase insurance for every single entity in which Penguin was obligated to purchase insurance for. That was required before starting on the project. So Panava at some point had to know who Penguin had to insure. That's the issue here. Penguin's contract said they had to insure the owner and the general contractor.
Under paragraph 5 of the Penguin Panava subcontract, does it matter whether ST is a general contractor or a construction manager?
No, Your Honor, and that's a very fair point because it could also be construed that Structure Tone was an agent of the owner. They were hired by the owner to run this project. So you could look at it twofold. Either they're a general contractor or an agent. Either way, they should be
Falls under
identified and
paragraph
insured.
5. Either way, they fall under paragraph 5?
I would think so, Your Honor. That's our position.
Can you, sir, address the argument raised by your adversary that a prima facie case was not made out because there are questions as to notice in the case with respect to use of the plank?
I apologize, Your Honor. At the very end of your question, I lost it in the...
Can you address the issue of whether or not a prima facie case with respect to negligence, I'm talking about your negligence, your client's negligence, how did you make out your prima facie on that issue in light of what your adversary is saying is that there are questions of fact as to notice?
Sure. Yes, Your Honor. I have 2 responses to that. First, the testimony of Panava's own project manager and foreman at the site, Jerry Demanchik, he testified that 285 Madison, Structure Tone, and RFR Realty had no direction and control over the work that they performed. And plaintiff Michael Dorsett testified...
I'm not talking about means and methods, not means and methods, dangerous condition.
Yes, Your Honor. The testimony of several of the appellants set forth that they were aware that the plank was there, but it was only supposed to be used for the egress of equipment. Individual people were not supposed to be walking over this plank. There was a door.
So you're conceding that there were people on notice that the manner of egress was how the plank was being used, correct?
They were on notice that it was used for equipment. They had no notice that it was ever used for individuals. They testified if they knew individuals were walking over it, it would have had to been stopped. There was a safety
Well, doesn't that raise an issue of fact ultimately? Aren't those just issues of credibility that have to be decided at trial as to what your clients knew about this dangerous condition?
As to the aspect of negligence, Your Honor, we request that there's a conditional order of indemnity. For defense and for insurance obligations, that's separate from negligence. The fact that there's claims here triggered those
So
obligations.
turning to the insurance obligations, isn't there a letter here? Aren't costs being shared here now? I think it was the Travelers that's.
Your Honor, we set forth on our brief and requested judicial notice be taken as to a declaratory judgment action that was filed in the Southern District of New York. There was a decision rendered by the Southern District that found that the insurance purchased by Panava was in fact on a co-primary sharing basis.
Thank you. We'll end it there. Thank
Your
you.
Honor.
Schaefer versus May.
Good afternoon, Your Honors. Joseph Scholes from McCarter and English for Appellant.
Counsel, can you tell me why May wasn't entitled to summary judgment where it seems like all of the facts, the undisputed facts, seem to establish that Schaefer didn't satisfy the promissory note?
I would argue
The
quite
confession of judgment, we have the pre-suit stipulation of settlement, we have the promissory note itself.
Oh, the terms of the note themselves are clear. However, what is not clear from the record is that Mr. May was entitled to summary judgment. In fact, the evidence shows that Mr. Schaefer did, in fact, repay that note.
Well, what about the email that was somewhat contradictory?
So the best place to start is that email. And this is an email sent in July of 2018.
You want to tell us which email you're referring to, what page it's on of the record?
I'd be glad to. So it's at page 660 of the record, and it's an email in July of 2018 that was sent by Mr. Schaefer just after he was fired by Argentum. So this is a key aspect of the court's ruling. And the court found that in that email, Mr. Schaefer admitted that he had not fully repaid Mr. May. In fact, the trial court misread the email. If you read the email, it clearly provides that Mr. Schaefer stated that he had, in fact, made Mr. May whole. And I'll read you the exact language of the email. While the trial court said that it shows that he hadn't repaid him, it's clear from the language that Mr. Schaefer was speaking in the past tense. So I'll read it to you. It says, "You should know that I saw my primary, secondary, and tertiary goals as making you whole." He goes on to say, so I did.
So that's essentially after the fact, correct? After the fact, all payments have been made. So let's go back to the earlier emails. For example, emails in January of 2018, where there's a reference to nut for the month, back office expenses. Seems to me that the parties understood that there were two kinds of expenses, debt service, and then these back office and other expenses. Isn't that what really was occurring based on a series of the emails from your own client while there was a relationship with the defendant?
At worst, Your Honor, there's a question of fact as to what those payments were made for. There is a list of each of the payments that our client made, and some of them do say debt miscellaneous on them. And in fact, the trial court assumed that all the ones that said debt miscellaneous were entirely for some business expense and not for the debt, which is contrary to what Mr. Schaefer testified. And to make the conclusion that each one of those payments in those categories were somehow solely for a business expense, which Mr. Schaefer was not obligated to do, by the way, to conclude that his testimony that was not so intended was incorrect is a credibility determination. In fact, if you go down that list of payments, each one of them that says debt miscellaneous, in fact, Mr. Schaefer did testify that they were intended to pay back the debt first. And another one of the key problems with the trial court—
But do the emails say anything like that? That these payments are intended to pay the debt first?
So there are two emails that are very, very clear that list the payments that he made, and I'll provide them both to you. On a March 18th email, 2018, which is at page 470 and 71, Mr. Schaefer states in that email what the total amount that he had paid back on the loan was at that point. If we look at the list of payments, and this is based on the actual bank records, If you look at the list of payments that he had made up to that date, it is exactly $81,000. And that list of payments includes payments that were made to Argentum for what they call business expenses. And the second email is from the next month in April, and it lists all of the payments that were made by Mr. Schaefer.
You mean the April 16th?
It's
email?
April 2018. I
April
believe it was the
16th,
16th.
2018.
I believe that's the one, Your Honor. And that's at page 741.
But even in that email, didn't some of them say that was for debt service?
So some
While
say
other
debt.
payments were itemized, both as debt/miscellaneous? I mean,
So here's the key problem with that. They say debt miscellaneous. The trial court improperly presumed that that payment in its entirety was for some business expense and not in part for.
Well, it has
debt
to be
service.
in part, because it says in that one, payments were itemized to May as debt service, but then there were other payments that were itemized to May and Argentum. Those were debt miscellaneous.
So those were payments that my client has testified were intended to pay back the loan first. And I will add that both of those emails, the March 18 and April 18 emails that he sent to Mr. May stating these were payments toward, including the Argentum payments that say debt miscellaneous that were made toward the debt, received no response from Mr. May.
But I don't understand how payments made toward Argentum could diminish his obligation to Mr. May personally, because the promissory note was not to Argentum, but to Mr. May.
Because
So I don't understand how you're combining payments made, some to the corporation, some to the individual, but that's not how the promissory note works. That only called for payments to Mr. May personally, right?
the course of dealing, as set forth in the record, shows that the parties did not follow the express terms of the note.
Well, I'm not sure if that's, I'm not sure that that would be, that Mr. May would agree that he didn't follow the terms of the note. I think he would say that your client didn't follow the terms of the note.
Well, here are some examples. Mr. May.
Why don't you give them to us on rebuttal?
Absolutely, Your Honor.
Thank you.
Good afternoon, Paul Consul for the respondent, Lawrence May. May it please the court.
Why aren't there questions of fact here, as counsel says? The emails seem to indicate, miscellaneous. If they don't indicate miscellaneous, it's debt service, but unclear as to what they go to.
Well, Your Honor, the emails say either debt or miscellaneous. And prior to the reply.
Well, debt service and debt miscellaneous.
I believe it's just debt slash miscellaneous, Your Honor. Prior to the reply, we never heard an argument that there should be an apportionment of which one it went to. That was not Mr. Schaefer's contention. Mr. Schaefer's contention up until.
Pardon me? He didn't raise that in his EBT? That's what your adversary suggested. That was.
No, sir. During the EBT, Mr. Schaefer very clearly couldn't apportion any amount to debt or miscellaneous. It was a series of I don't knows, I don't remembers, and then he said it could have been all for debt or it all could have been for miscellaneous. Nonetheless.
So the argument was there. I mean, they were making the argument. It doesn't sound like it's a new argument, correct?
I'm sorry, Your Honor.
It wasn't raised in the reply. It was obviously raised by the client in the EBT.
The argument was not raised by the client. Mr. Schaefer refused to give a clear response other than could have been in the EBT.
But does that raise issues of credibility that we shouldn't be opining on?
No, it's not credibility because it's a feigned issue of fact. If you look at the emails, if you look at his prior emails, if you look at the course of conduct, if you look at the exact statements in the emails, the inexplicable overpayment, his own memo on the checks to Argentum, it was not a party to the promissory note, it's a feigned issue of fact. And it's trying to strategically conflate payments to Argentum for overhead with payments for the debt at the end of the day. The emails are not, each one of them implicates Mr. Schaefer in an agreement to contribute for Argentum overhead. The April 16th email indicates that Mr. Schaefer's paid more than the amount of the loan at that point in time, but doesn't say, I satisfied the loan. It's payments that were towards our, part of it was for Argentum, part of it was for the loan. At the end of the day, the July 9th.
May has a payment schedule showing the
That's
80,000.
correct. That's
due.
correct.
And defendant Schaefer doesn't really successfully refute it, because while he has these payments that he's made, he either doesn't recall what the breakdown is between the payback of the original loan and what's for the back office expenses. And there are these emails which he, again, is not able to specify, is he, as to what's payback of the $320,000 loan and what reflects the back office expenses. And so that in the face of that $80,000 payment schedule, you really don't have an admissible evidence, any admissible evidence putting that in question.
That's correct, Your Honor. And I believe we're running out of time, but just very quickly, Schaefer's contention is that every dollar went to pay the loan. That's clearly incorrect based on his own emails and his own, the calculations submitted by Mr. May. Thank you. Unless there's anything else.
No. You have 52 seconds left. You don't have to use them, though. So if you're done.
I'm sorry.
It's okay.
Okay, thank you, Your Honor.
You're welcome.
Very briefly, if I can return to the point that Your Honor asked about how the parties did not follow the terms of the note. The evidence is clear and unrebutted that Mr. May advised Mr. Schaefer that he didn't have to follow the payment schedule in the note. And in fact, that is the course of dealing the parties followed in this case.
But wasn't the note, didn't the note specifically say it could only be modified by something in writing?
And New York law makes clear that where the parties' course of dealing modifies that, they can do that. So for example, Mr. May claims in his affidavit that Mr. Schaefer made equal payments of $5,000 and $66 monthly. And in fact, the evidence, all the payments on the record show that they were almost never in that amount, and they were made on various dates. The note also required that payments be made directly to counsel for Mr. May, which didn't happen. So Mr. May was happy to accept all these payments, both to himself and to Argentum, toward the note, as made clear in these emails.
And where did he say that payments to Argentum constituted payments on the note which he had personally signed?
Mr. Schaefer said that directly in both of his emails, the March and April 2018 emails. And I may add, in the July...
Could you give me the record site on that? I don't recall that.
So he lists, the record sites for both of those emails are as follows: 470 to 71 and 741. And in those emails, he lists as payments toward the debt, payments both to Argentum and to Mr. May. In fact, looking at the March of 2018 email itself.
The one on 741 was from your client, not from Mr. May.
Correct. Mr. May did not respond.
That one doesn't establish that Mr. May agreed to that.
He didn't respond either. He did not
Well, that doesn't
ever
mean
respond.
he agreed to it.
He accepted it by acquiescence, and he didn't dispute it. And I may point out that the July email...
And the one on page 470 was also from your client. Neither of those established that he agreed to that.
Correct. By course of dealing, he accepted it by acquiescence. He accepted these
So
payments.
is there anything that you have in writing from Mr. May agreeing that payments made to Argentum would reduce your client's debt on the personal note from him?
I would surely submit that his acceptance of those payments and not responding to these emails in which they're clearly identified.
So the answer is there is nothing in writing from him agreeing to that, right?
Expressly, no.
Okay.
So the last point that the trial court made was that there was an overpayment, is somehow an indication that he didn't pay the debt, is, again, a credibility determination that the trial court made. Mr. Schaefer said in his affidavits clearly, I intended my payments to go toward the note first. and then toward anything else. There was never an agreement for him to pay business expenses of Argentum.
Thank you.
Thank you.
Thank you both. People of the State of New York versus Cohen.
May it please the court, Mark Rube for the people of the state of New York. For years, respondents misrepresented the status of...
Is there any question that at the time you commenced this action, was it in 2018?
2018, that's correct.
2018, that at that time the statute of limitations was only 3 years?
Well, under Credit Suisse, the New York Court of Appeals held that the statute of limitations was...
At that time, there's no question the statute of limitations was 3 years. By the way, there's a motion for re-argument pending in front of Judge James on this. Has that been decided?
It has not been decided last time I checked, which was very recently. Yes, but the legislature clarified in 2019 in CPLR 213-9 that the statute of limitations had always been 6 years, as this court had held for decades before the Credit Suisse.
Are you entitled to the retroactive application of the statute under these circumstances?
Yes, this court has held in Allen and in Jewell that 213-9...
So in those cases, it's true we've held that it's retroactive, but in holding that it's at that time, when the actions had been commenced, the change in law had already gone into effect, which is not the case here. Does that make a difference?
No, it does not, because the court applies the statute of limitations at the time it makes its decision. And we cite a number of cases, including the matter of Gleason case itself by the New York Court of Appeals, which involved a similar scenario where the legislature corrected a decision of the New York Court of Appeals. And in that case, it was up in the appellate division when the legislative amendment was enacted, and the court...
Had the legislature in this case acted before the trial court made its decision?
Yes.
So that by the time the decision was made, the new legislation saying 6 years was in effect?
That's correct. So the decision was incorrect at the time it was made. The legislation came into effect while the motion was submitted. And there's no reason to reach a different result here than in Allen. The legislatures often amend the statute of limitations, and the question is whether it should be given retroactive effect. This court has already determined that question. Once it is given retroactive effect, it is applied to all pending and future cases. I'll turn to the merits of the petition if the court has no more questions about the statute of limitations. Supreme Court held that there were violations of the rent stabilization law. It dismissed the claim because it viewed those violations as time-barred. But once
should Supreme Court, in the first instance, decide those issues on the merits?
Well, this court has the discretion that it could allow the Supreme Court to decide that in the first instance. We submit that because this is mostly a case of documents which are on the record, that this court is positioned to grant the petition. I would just
What about with regard to the other claims, the 7, 8, and 10, I believe? Should those not go to trial? Or are the issues there with regard to the security deposits, et cetera, clearly stated?
Yes. With respect to the security deposits, the court can simply look to the canceled checks that are clearly labeled security deposit, return of security deposit, and one can see that no interest was paid. With respect to count 10, I would just emphasize, I'm sorry, the purchaser and the rent roll. I would emphasize that with that there's a Section 6312 claim that doesn't require reliance. So that claim can be granted as to 6312, and there's only really a question of the common law claim, which was raised because of Credit Suisse and the different statute of limitations that were applied at that time, but substantively it wouldn't have any effect beyond the 6312 claim. But the Supreme Court held that it was a properly stated claim, and we submit that this court can grant that claim as well. I would like to emphasize that this court would have to address, at a minimum, the Supreme Court statement on the Martin Act, where the court held that, separate apart from the statute of limitations, that there was no Martin Act claim because it's not illegal to require tenants to sign a renewal lease. And we submit that that's wrong for two reasons. First of all, under the Martin Act, when there's a pending cooperative condominium offering plan, tenants cannot be evicted for any reason relating to the expiration of tenancy. So the Supreme Court statement is wrong as a matter of law under the Martin Act, but it also—
Was that dicta given its holding as to the statute of limitations?
I'm sorry?
Was that dicta given its holding as to the statute of limitations?
On the Martin Act, it's not exactly clear to me because the sale of the building was within the 3-year statute of limitations, but the court did find ambiguity there and give that as an alternate ground for dismissal of the Martin Act claim.
Thank you.
Good afternoon, Your Honors. My name is Hartley Bernstein, the law firm Bernstein Cherney. May it please the court. We're here today because the Attorney General is trying to salvage an action that never should have been brought in the first place. But I'm going to go directly in first.
I think we're here because the trial court made a decision which the Attorney General disagrees with. Let's start with that.
I'm sorry.
I was just disagreeing with your characterization of why we're here, but go ahead.
Okay. I want to go directly to the statute of limitations issue because I think that's key to everything that was decided in the Supreme Court. And it's important to note the sequence of events here and why it distinguishes it from other cases and why it was correct for the Supreme Court to decide that the 3-year statute of limitations applied. This case was filed by the Attorney General's office in October 2018. 8 months earlier, actually 8 months earlier.
Right, but the question do you agree that at the time the motion court made its decision, the legislature had changed this, had passed legislation stating that the statute of limitations was 6 years?
Yes.
And that was in effect at the time that the decision at issue was made?
I can agree that between the time that the petition was filed, the motion to dismiss the petition was filed, and then the court decided the motion that the legislature expanded the statute of limitations.
Well, wait a minute. It didn't expand it. It was always for generations. It was 6 years. It was just in 2000. It was in response to a Court of Appeals decision that shortened it. Correct?
I'm sorry, I didn't.
I'm saying it was always 6-year statute of limitations. It wasn't an expansion. Court of Appeals retracted it, and the legislature went back to the original statute of limitations as found by our court, I think, back in the early 90s.
Correct. But at the time that the action was filed, this petition was filed, the Court of Appeals decision stood. The statute of limitations was 3 years. The ability of a respondent or a defendant to respond to a complaint or a petition is a snapshot in time. The defendant, respondent has a period of time in which it either can answer and raise it as affirmative defense, or file a motion to dismiss based on it, on the statute of limitations, among other things. At the time that my clients were entitled to do that, the statute of limitations was 3 years.
No one's faulting your client for having made the motion. The question is what law the court should have applied in deciding that motion, isn't it?
But the question is at what period of time you'd be judging the statute of limitations?
But we've already found in 2 cases that the statute of limitations here is retroactive. It has retroactive application. That's been determined.
And the distinction between this case and the Allen case is that in that case, the case was filed after the legislation was passed. So at the time that petition was filed, the legislature had already acted and expanded the statute of limitations from 3 to 6 years.
But that's to ignore that for all of the years prior, as my colleague said, it was a 6-year statute of limitations with regard to the Attorney General's ability to bring certain cases. So it was only that very small window where the Court of Appeals applied it in that one instance, and it was immediately changed.
It was during a small period that window was open, but that was the small window during which the Attorney General's office decided to file this petition. If they had filed it a year and a half later, we would be having probably a different.
I guess you're asking.
Does that argument makes no sense to me. I mean, it just doesn't. I apologize for saying that. So they could file it later and they get the 6 year because they file it. Now they don't because the legislature decided to change what the Court of Appeals found?
Well, conversely, if the legislature had done the opposite and the statute of limitation had been 6 years and shrunk it to 3 years, and while my case was still in front of the court, would we have been entitled to go in and now plead a new statute?
You know, that's a question I don't have to answer, thank God.
I think that this is a unique case based on timing, which is distinguishable from the Allen case, and which would require the court to apply the 3-year
If your
statute.
position on the statute of limitations was accepted, would there be anything which would stop the Attorney General from just turning around and refiling its petition? Now that there's a 6-year statute of limitations in effect?
I don't know the answer to that question, and that's not something that I've explored, whether or not they have. Obviously, if they couldn't go back as far as they would have 3 years ago when they originally filed this case. So I don't know that any of it would fall within the 6 years.
Well, certainly the sale of the building would fall clearly, right? That would be, if they recommenced, it would be 6 years prior when the building sold in 2018?
Yes.
So anything relating to the sale would still be good, right?
The Supreme Court found also that this case was, and that a number of the causes of action needed to be dismissed because the facts, as alleged in the petition, didn't support them. For instance, the Attorney General has made arguments that the tenants were required to vacate their apartments. They based that, as the Supreme Court found, solely on third-party testimony that didn't specify the dates that these tenants left the apartments, an affidavit from a real estate broker who helped one tenant find an apartment sometime in 2015, whereas the respondents presented an affidavit from that tenant who stated that she was never asked to vacate the apartment. I think the Supreme Court rightfully found that to be more credible.
Counsel, if you have any other issues, you should get to them because you have only a little over 1 minute.
I'm sorry?
I said if you have other issues, you should address them because you only have 1 minute left at this point.
I understand. And I guess the other principal issue that they seem to rely on is claiming that this gentleman, Vincent Wu, who purchased the building, was deceived because he relied on misleading rent rolls. There's no evidence they ever spoke to Mr. Wu. They conducted an extensive examination before.
How do you respond to your adversary saying that, at least with respect to 6312, reasonable reliance is not an element of that statutory claim?
Well, the court found that there was nothing that they had shown in terms of reliance, and asked and said that this would be put over to a trial But I suggest that there's nothing that indicates that Mr. Wu ever relied on anything.
But that's what I'm at. Does 6312 require reasonable reliance?
Right. Thank you.
One of the issues you raise is that you haven't been furnished with witness statements. What is the status of that?
Well, again, in terms of the interest payments, there's no question here that all of the tenants received back all of the security that they paid. In terms of interest, the Attorney General presented 6 checks over 7 years that were securities checks. They've presented no bank statements, nothing that would show that they were improperly commingled, nothing to show that interest wasn't collected on them, other than the conclusion and the anecdotal notion that there was no interest collected and that it wasn't paid. But they admit that the tenants received back all of their security. So I think that that is another claim that's just made out of a whole cloth.
Thank you.
Thank you.
I'd just like to try to make 3 brief points. On the statute of limitations, this court in Allen, in assessing the reliance of a litigant on statute of limitations, looked to the time that the litigant acted in the relevant conduct, not when the complaint was filed. And in Allen, this court noted that the limitations period was well known to be 6 years when he engaged in the fraudulent conduct, and the same analysis, the analysis is the same here. During all the period of the alleged conduct, it was well known that there was a 6-year statute of limitations. So there's no reliance on Credit Suisse. Just one quick correction. I think Justice Singh asked about when the building was sold, and it was sold in 2016. I don't think it makes a difference, but I just wanted to clarify that. And I wanted to clarify that under 6312, the no reliance requirement is in the Trump Entrepreneur Initiative decision from this court in 2016. Unless there's any further questions, I know there's a lot of factual detail here, but I think the important, the scheme itself is factually simple, and this court should reverse the decision below.
Thank you. Thank you both. 373-381, PAS Associates versus IDECO.
Good afternoon, Your Honors. May it please the Court, Joshua Kapelowitz, Fox Rothschild for Plaintiff Appellant. We submit that the Supreme Court erred in denying plaintiff's motion for summary judgment and sui sponte granting summary judgment in favor of defendants.
Counsel, was the leased space that your clients are in affected by the pandemic restrictions that were set by the government?
No, Your Honor. The leased space, as set forth in the lease, is for office space. That's what the articles provide, and all the case law is clear that office space is not one of the premises that is affected by any of the pandemic executive orders or the guarantee law.
I said your client. I didn't mean your client. Sorry. I misspoke.
Correct. Thank you, Your Honor. This space in particular is a space, Suite 1101. It's a simple office space. It's no different than any other office space in the city, although my client would like you to know that.
Does it matter that the tenant is a large-scale live events coordinator, so presumably that's the business that dried out? Would that make a difference here?
It doesn't, Your Honor. I appreciate the question. The courts uniformly have stated that office space leased for office space is paid for regardless of what they use what their
This wasn't allowed to be. This wasn't allowed to be used for something other than office space, right? Under the
Correct,
lease,
Your
it
Honor.
had to be used for office space.
It could only be used for office space, and there's a case directly on point that is I think very telling by Judge Bluth, whereby it was 757 3rd Avenue, I may be getting the first part of that wrong, versus Grant, Hyam Grant. And that's a case where actually the tenant leased office space, sort of like a WeWork, and it basically did floors, and their business model was to then license that office space to other parties who are going to use it, and they were unable to do that. Unfortunately, pandemic, people didn't come in and the like, and as Justice Bluth wrote, and we agree with her, which is you lease the space for office. I'm paraphrasing, that's not what she said. You lease the space for office, it's to be used for office. There are no executive orders that don't allow you to use for office. That your business plan now has unfortunately not been effective or crumbled, or you're not making a profit, is not the purpose. It does not affect this lease and this contract. It does not make the landlord have to suffer with you. They're not your partner.
We understand. So you're asking for summary judgment on liability and damages here, correct?
Correct, Your Honor, against tenant and guarantee.
Did you submit any proof other than as far as damages are concerned, aside from the ledger?
No, Your Honor, the ledger was submitted. It was unopposed. There's been no questions about calculations or that the money's owed. And in fact, tenant and guarantor admit, both through express admissions and through omission, that they have not paid the rent since April 2020 to present. The lease runs through December 31st, 2023. So there was no argument below as to the amount of damage or otherwise. If there are no further questions, Your Honor, I'll yield my time to my friend. Thank you, Your Honor.
May it please the court, my name is Judah Cohen and I represent the defendants, Ideco and Mr. Korn, the personal guarantor.
I'll ask, I'm sorry?
Ideco and the personal guarantor on the lease. It's our position that EO 202.3, which shut down large gatherings, which represented the core business of Ideco, is the definition of why we're here under.
But how is that possible when the lease itself said that large-scale live events were not to take place in the space? It was only to be used as offices, so it was never a live space
I understand that, Your Honor, that in fact the office space was used for office work, but the core business of Ideco is in order to facilitate large-scale concerts, festivals,
But the lease wasn't speaking to what your corporation was, the purpose of the corporation was speaking to the leased space that you leased, that you had your offices in.
Well, the same thing happened in 274 Madison, in which this court, I think Justice Singh was on that particular bench and panel. That was a language school that was rented out as office space. And that one office space was also utilized as a language school. There, this court stated that they were compelled to shut down.
In this case, the space was only used as an office space. There's nothing to...
There is nothing...
Excuse me. Perhaps you could show me where in the record there's anything that shows it was used as anything other than an office space, especially because the lease says that's the only use for which it can be used.
Your Honor, that may be so with respect to the lease, with respect to the fact that it was used, in fact, as an office. But the purpose of this business was to facilitate large-scale events.
But you just cited a case where you said it stood for the proposition that supports, a position that supports you. But in the case that you cited, you said it was a school that was used as it was an office for a school, but they also had classes in the space. That's not the case with your space. It may be a live event company, but it was only used as offices. They didn't have parties there or any other live event, as far as I can see from the record.
But I understand that, Your Honor. However, there is nothing in the executive order or in 22-1005 that precludes this particular formulation that we have propounded here.
Counsel, how do you deal with paragraph 27 of the lease, which says that your client was not excused from paying rent because of its inability to perform any of its obligations due to reasons beyond its control?
That may be so with respect to the actual tenant, but not with respect to Mr. Korn, who's the personal guarantor. Under 221005, because 202.3, which was that executive order that precluded large-scale gatherings, they were not able to perform the core of their business whatsoever. It doesn't really make a difference whether it's in the office or outside of the office whatsoever. What matters is whether the core business that we're trying to protect here and the personal guarantor, Mr. Korn, from paying was absolutely 100% shut down by the executive order. And the particular executive order, EO 202.3, shut down large-scale gatherings. The salient purpose of 22-1005 is in order to protect personal guarantors. Now, if I may pivot just for a second to the tenant himself, to the IDECO, the corporation.
Well, your time is up, but I'll give you another minute.
Thank you, Justice.
Wrap it up.
We are drawing a distinction between the personal guarantor and the tenant. We also do concede that the lower court got it wrong in dismissing the entire action sua sponte. But be that as it may, on this record, they didn't establish their prima facie entitlement to all of the damages, especially under the acceleration clause. That acceleration clause has been the subject of several lower court decisions in which it's saying that paragraph 18 of that acceleration clause is in the form of a punishment. And one last thing, they themselves relet the premises, and under that particular clause, they're not entitled to their full measure of damages. So this case should be remanded back only on the tenant, full discovery, trial, and whatnot. But by the same token, Mr. Korn, he should be let out of the case under 22-1005. Yes, Judge.
I just want to understand, in a nutshell, your adversary argues rent's been owed since April 2020 to the present.
I'm sorry, I can't hear you.
Your adversary argues that rent was owed from April 2020 going forward. You dispute that, correct?
That is correct, Your Honor. We absolutely 100% dispute that. During the critical period of time, we did not pay rent. And then in the fall of 2021, which I believe is towards the record, but it's advertised on their website right now.
Well, we don't want anything towards the record. Thank you very much.
Thank you.
Thank you, Your Honors. I just one quick point, and then I'll answer any questions you have, or maybe two if you'll indulge me. I think that there's some conflation here going on, which is that 202.3 affects people that are in business, doing restaurants, nail salons, technicians, massage parlors, and the like. That's not what this contract's about. That may be for my friend's client's contracts that he has with Ticketmaster and Westbury Music Fair and the like. This contract's about a lease. This gentleman guaranteed, Mr. Korn guaranteed this lease. So the fact that his business model may have failed with his outside vendors, that's unfortunate, but it doesn't change the guarantee and it doesn't change the lease. And in fact, both the lease and the guarantee, as the court astutely pointed out with respect to the lease, say you have to pay the rent no matter what. Article 27, force majeure, and Article 3 of the guarantee says you have to pay the rent no matter what.
But also, under EO 202.6, doesn't the tenant have to be a non-essential retail establishment? So it doesn't meet that criteria, what you referred to, barber shop, hair salon, tattoo parlors, et cetera, et cetera.
Correct, Your Honor. And to that point, it absolutely says that, and my friend to my right dropped the word retail in his opposition, but that's an important point, and that also goes to the Vieira case, which this court decided earlier, where the school was a front-facing school, had a back office, like a lot of retail establishments does, is a for-profit school that was zoned for retail and used as retail, so it's not really applicable here. With regard to, if you'd like me to address the damages, with regard to acceleration.
Thank you.
Thank you, Your Honor.
Greenway Muse versus Liberty Insurance. Counsel, I cheated you of your time when I was calling the calendar. You asked for much more. I'm going to give you 7 and 2, which will equal the amount of your opposing counsel, okay?
Good afternoon, Your Honors.
Good afternoon.
Gary Soretsky, Katzendranoff, for plaintiff Greenway Muse and interpleader defendant Seneca Insurance Company.
I'm just going to ask if you could speak up. I heard what you said, but yes, if you could train that a little bit more closely.
Thank you.
So I'll just ask you this. Given the history here, why should Greenway and Seneca be entitled to prejudgment interest?
I'm sorry, Your Honor.
So why should your client, Greenway and Seneca, be entitled to prejudgment interest on the UAD judgment? Wouldn't that be a double recovery?
No, not at all, Your Honor.
Why not?
It's not a double recovery. Well, let me just start.
They were already entitled to prejudgment interest on the original judgment, right?
There are two separate actions. There will be two separate judgments, and there are separate breaches. So there is not one monetary obligation, to use the phrase that was used by the motion court. And the reason for that is that the judgment against UAD,
Yes.
the negligent contractor, already includes prejudgment interest with respect to UAD's breach, UAD's failure to adhere to the contractual indemnity
What was the basis for
obligation
the
of the
second action?
construction.
Was it a statutory action, a 3420 action, correct?
I'm sorry.
You brought a 3420 action, correct?
That's exactly right.
Okay, so is there a case law which supports the proposition that for a 3420 action, you're entitled to statutory interest?
There are cases cited in our briefs, but, and
Is there a case that gave interest on a 3420 action in similar circumstances where there was another underlying judgment?
I think that there is, I think Daddario is, and the reasoning behind it is this, Your Honor, that in a 3420 direct action, a 3420 direct action is brought pursuant, obviously, to Section 3420 of the insurance law. That statute gives the judgment creditor the right to directly sue an insurer that has failed to satisfy a judgment against its insured within 30 days.
Prejudgment interest. Don't we have to be talking about a breach of contract claim? And what contract is there here that's been breached? To this point in time, we don't even know exactly how much Seneca Greenway is entitled to.
The contract that has been breached by each of the insured defendants are the policies that they issued to UAD. That's the contract. That's the breach of contract. And they were obligated under the insurance law to satisfy the initial judgment within 30 days. They didn't. Insurance law 3420.
The basis of this action is not the breach of contract. It's insurance law 3420.
3420 is merely, I hate to minimize its importance, but it merely authorizes the judgment creditor to sue the insurer for breach of contract. So it is a breach of contract action. And under CPLR 5001A, prejudgment interest is mandatory. And there is significant case law, including from this court and the Court of Appeals and the Second Circuit applying New York law, that in breach of contract actions, prejudgment interest is mandatory.
Except you couldn't have sued in breach of contract. You needed the statutory predicate, right, to bring your lawsuit.
Yes, that's correct. But the statute is the predicate. The statute enables an unsatisfied judgment creditor to bring a breach of contract action against the breaching insurers. And I might add at least two things, but I might add that
Counsel, is the basis
the
of your-
defendant insurers, except for a limited 5-month period, do not dispute the entitlement to prejudgment interest, nor should they, because it's required as a matter of law.
How do you get to these breaches that you're discussing? Liberty wasn't even withholding the funds. They're simply waiting for the court to resolve whether the funds can be deposited in escrow, and pending a resolution of the dispute between Seneca and Federal.
I'm sorry, Your Honor.
Liberty is not withholding the funds. They're waiting for a resolution whether the funds can be deposited in escrow. They're waiting for resolution between Seneca and Federal. How does that give rise to a breach of contract that should impose their having to pay prejudgment interest?
Because they are obligated under 5001A to pay prejudgment interest for breach of contract.
Do we know how much at this point, do we know how much Seneca is entitled to?
At this point in time, based upon, again, 5001 of the CPLR, the direct cause of action accrued on January 4, 2018.
Do we know how much Seneca is entitled to?
It's approximately $2 million.
Okay, let's hear from...
in the direct action.
Okay,
And
thank you.
Let me just add one other thing. I see that I'm already...
Okay, I'll give you 30 seconds to add one more thing, then you can finish up.
Aside from the fact that the defendant insurers don't dispute the entitlement except for a 5-month period, and that 5-month period incorrectly conflates prejudgment interest with post-judgment interest, the prejudgment interest for breach of contract, without the prejudgment interest, there is no consequence to an insurer that does not satisfy...
So in your argument, purpose of interest is to punish. I always understood that the purpose of interest is to make up for the loss of that ability to have money, so isn't that inconsistent with why we grant interest?
That's correct also, but it also acts as an incentive to a liability insurer to comply with its contract, the policy, and the insurance law.
Thank you.
Which requires payment within 30 days.
Thank you. We'll hear on rebuttal from you again.
Other than that, and other than on rebuttal, we rely on our briefs.
Okay, but you will have some time.
Thank you.
Good afternoon, Your Honors. George Harden, Cunliffe, McCann, and Paletto for the respondent, Liberty Insurance Underwriters, Inc., or LIUI. Plaintiff's claims in this case for interest, for attorney's fees, and for a judgment under 3420A are completely and totally premised on an alleged breach of contract by LIUI, which purportedly violated its policy terms and purportedly violated 3420.
Well, has, as my colleague pointed out, LIUI been ready, willing, and able, and wanting, in fact, to make the payments?
Since December 2017.
And what's been the hangup, why the payments weren't made, based on the tortured history of this litigation?
I'm sorry, Your Honor, again?
What was the hangup? What was the hangup?
The hangup has always been that Seneca Greenway, because Greenway's paid no money, this is really Seneca's subrogation claim we're litigating, has refused and has insisted that LIUI's obligation was to pay only Greenway, disregarding the subrogation rights of federal insurance. And because we failed to do that within 30 days of the judgment against UAD, we somehow violated our policy.
But you always had the problem of not knowing to whom to give the money, because if you gave it to one, the other one was going to come after you.
Exactly, Your Honor, exactly. We were always subjected to multiple liabilities. We were always subjected to the claim by federal that we paid the wrong party. And
it's always been unclear how much money you owe and to which party.
That's correct. We knew how much money we owed to satisfy the UAD judgment and to satisfy...
But you didn't know its division.
But we didn't know its division. And therefore, we had to resort to an interpleader. We thought we had a settlement on more than one occasion. As Your Honor knows, it was determined that there was not adequate documentation, but that it was clear we offered our policy and pre- and post-judgment interest at that juncture. So our interest obligation was fixed on May 25, 2018. That was reviewed and determined by this court. It was reaffirmed by this court in its decision of December 14, 2021. We are here today with the third attempt by these same parties to, again, try to achieve a judgment against LIUI and INIC, when in fact we have repeatedly offered to pay our limit, repeatedly offered to pay pre- and post-judgment interest. The court below has scrutinized our calculations of that interest, has agreed with the calculation, has finally permitted us to deposit our money into court. Previously, our money was sitting in an escrow account for the Greenway attorneys. We supplemented it based on the decision of this court as to when the interest obligation terminated. And we did the calculation, which the court below accepted and permitted us to deposit all monies into court as it now has been done, and then subsequently granted our motion for a dismissal of our obligation for the UAD judgment.
Thank you. Let's hear from federal.
Thank you, Your Honor. May it please the court, my name is Timothy Keene, Cork and Backlow PC for Federal Insurance Company in this case. I'd like to start by addressing, if you don't mind, this side of the bench. You three, on my left, were on that panel back in 2020.
We're painfully aware of that.
Not surprised, my apologies. And I won't belabor it, but consistent with what Justice Singh was speaking of a moment ago, this court went out of its way and took an unusual step to say, these people came in good faith on May 25, spent the day with Justice Shulman to resolve this, put up their money. Now, I would stand to benefit if what Seneca, I say I, my client, would stand to benefit if what Seneca said about interest streams was correct. I believe it was in response to Justice Friedman's question a moment ago, and I may not have heard perfectly well, I hope I did, that Seneca's counsel for the first time said, I believe, about $2 million would be what Seneca would be due. If that had been said over the years of torturous litigation, in this case, in the courts below in particular, we could have been done. This is the third time they have us here. So they've previously said, no, they're due everything, $5 million, $6 million, including, of course, the 2.3, which I briefed, and I'm happy to rest on the brief unless the courts have, the justices have a question. But it's been determined, notwithstanding that Federal's never made a motion, Seneca's made motion after motion, took appeals to this court on the issue that they pressed to the lower court. It was a dispositive issue on a 3211 motion. They said, Federal has no right. That's not what the lower court said, very plainly. Again, unless the court has questions, it's my pleasure to rest.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Lawrence Klein with Robinson & Cole for Illinois National Insurance Company. I'll be very brief. We don't believe that that Seneca has made any arguments in the papers that are on appeal now. The orders were against liberty and liberty only. The only thing I'll say that the only reason, as I think the court has recognized, that the payments haven't been made is because Seneca refuses to understand that it's not entitled to Federal's money. I've been holding $2.7 million in my escrow account for over 5 years. It has not been collecting interest by anybody, and that is due to Seneca's conduct on this case. Other than that, I rest on my papers.
Thank you.
Thank you.
Briefly, Your Honor, with respect to the excuse, so to speak, for the defendant insurers not satisfying the judgment against UAD, and that is that they didn't know who to pay. They didn't know who to pay.
But isn't it a fact, counsel, you demanded the entire judgment? In effect, you demanded the amount that would have gone to Federal as well?
I'm sorry, Your Honor.
It's okay. No questions.
Counsel, I have a question which may be naive, but does anybody, your client, for example, ever consider the ratio between the amount of money that has been spent on lawyers and the amount of money that would be spent if they just paid the amount at issue? Does anyone ever think about that or discuss that or consider that?
We have had, as the record will show, there have been attempts to resolve this.
No, that's not what I asked. I asked you whether anybody ever thinks about what the ratio is between what you've spent on lawyers and what the amount at issue is in terms of payment to the party who is seeking payment.
I am sure, I don't have personal knowledge, but I am sure that that's a consideration. I'm sure it is. I want to address what I
Yeah, the underlying problem seems to be that Seneca doesn't believe that Federal is entitled to a portion of this.
That is correct. Federal is not entitled. That's not an issue on these appeals.
I understand that, but that's why this battle continues to go on.
As a matter of law, Federal is not entitled to any portion of the funds that either LIUI or INIC eventually pays. As a matter of law.
Sounds like that money's going to be in escrow for another, I don't know, several years.
But let me just, I know that my time is up and I apologize for this, that the excuse, and I'll call it an excuse, for LIUI and INIC not paying, and that is Federal's claim, overlooks the fact that INIC made a motion in the court below to substitute Federal and Seneca as judgment creditors in place of Greenway Muse. That motion was denied. There was no appeal from that judgment, either by INIC or by LIUI. Federal has, in the years that these litigations, these related litigations have gone on, Federal has never made a claim against either LIUI or AIG, presumably because it believes that it doesn't have a claim against LIUI or AIG. And the constant reference to the interest cutoff of May 25, 2018, when there was a mediation, that again conflates post-judgment interest. The decision of this court with respect to the May 25, 2018 so-called cutoff date applies only to post-judgment interest on the judgment against UAD. It has nothing to do with pre-judgment interest that is owed in this direct action.
Thank you, sir. Thank you, sir.
Thank you.
Thank you all.
And again, we otherwise rely on our briefs, and thank you very much.
Understood. Gardner versus the City of New York.
Good afternoon, Anthony Makarov from Gersowitz, Lebo, and Cork for the appellant. In order to survive summary judgment for the defendants, they have to create an issue of fact as to whether Mercer, the driver, was in the intersection before plaintiff approached. Or in other words, who was in the intersection first? They attempt to do that in two ways, both of which fail. The first is through the driver's testimony. The driver
Tell me about the collision. Just go back and tell me what happened here. Was this a rear-end collision or some other kind of collision? Side swipe?
This is a broadside collision.
Wait, broadside, is it rear end or not a rear end?
It's a T-bone collision. So the front of the defendant's vehicle came into contact with the driver's side front door of the plaintiff's vehicle.
Intersection collision.
Intersection collision.
You can continue.
So under 1142A, plaintiff's approach wasn't governed by a stop sign. The defendant's approach was governed, which means that plaintiff had the right of way. That's undisputed. Plaintiff's testimony establishes prima facie that she did have the right of way.
Mercer testified, did she not, that she was almost through the intersection when the plaintiff hit her?
She did testify that she was almost to the intersection, but judging by the pictures, you can see that plaintiff was also through the intersection when the collision occurred.
So why aren't there issues of fact here? How are you entitled to liability, summary judgment, when just based on what you're saying, sounds like there are issues of fact?
So under 1142A, the case law is clear. The material issue of fact is who entered the intersection first. The testimony and the pictures are clear that plaintiff entered the intersection first. No matter what version of Mercer's testimony you want to accept, she didn't see plaintiff until the impact. So she can't say, she can't tell us or give us any information about the vehicle's respective positions in the intersection or before they enter the intersection.
Is that the way Scott saw the accident?
Is that the way, sorry?
Is that the way Scott saw the accident? Is what you are saying consistent with the opinion of the expert, Scott?
The accident reconstructionist.
The accident reconstructionist, he uses a distance analysis that is not admissible, right? But his distance analysis concludes that plaintiff was 200 feet away from the impact location 4 seconds before impact, when Mercer was 60 feet away from the impact location 4 seconds before impact. But his opinion...
Why doesn't that create a question of fact?
No, because that opinion is inadmissible, because the distance analysis relies on plaintiff's speed that's given to him by a computer program for which there's absolutely no evidentiary foundation. It's Court of Appeals precedent that even in opposition to summary judgment motion, expert affidavit that relies on outside material in this case, a computer program, it's not admissible unless there's foundation for its reliability and accuracy. There's absolutely nothing in the affidavit that says that it's something that's commonly accepted by the experts in this field, and there's nothing in the 35-page report, or however many pages it is, that says that the computer program is something that's relied upon by the experts in the industry. There's absolutely no evidentiary foundation. I've cited a plethora of Court of Appeals cases and First Department cases that are rejecting expert affidavits that are not providing that foundation that's necessary for outside, out-of-court material.
Okay, you've made your point on that. Do you have another issue you wanted to discuss?
I just wanted to get across that Mercer, it's clear she testified about 7 times that she did not see the plaintiff's vehicle until the moment of impact.
I'm sorry, didn't she say she was in the intersection with her foot on the brake because there were pedestrians? Did she say that?
Sorry, could you say?
Did Mercer say that she was in the intersection with her foot on the brake because there were pedestrians in the walkway at the time of the impact?
Right.
So based on that testimony, isn't there an issue of fact as to who got into the intersection first?
No, because the pictures also show the plaintiff was also almost through the intersection as well. And she did not see the plaintiff until the plaintiff was also in the intersection. She testified about that twice, I think at 606 and 607 on the record, that when she first sees the plaintiff is also right on her in the intersection.
Could that be influenced at all by the speed of the plaintiff's vehicle?
One, we don't know the speed of the plaintiff's vehicle. The plaintiff testified that she was going 20 miles an hour, which is below the speed limit at the time. Again...
It's a pretty hard impact, no?
Sorry?
Pretty solid impact in this case?
I really don't know how to quantify that. Mercer testified that it was a heavy impact, but she's driving a very heavy bus at about 20 miles an hour. The plaintiff's driving 20 miles an hour. That's enough to cause the damage that we saw in the photographs. It's damage isn't out of the ordinary.
Thank you. You have rebuttal time.
Good afternoon, Your Honors. May it please the Court. Dean Pillarella for defendants' respondents.
First and foremost,
plaintiff failed to carry her prima facie burden here because the parties' conflicting testimonies were annexed to her initial supporting papers. My client, Ms. Mercer, testified specifically that as of seconds prior to impact, she was almost through the intersection, yielding for pedestrians in the crosswalk at the complete opposite side of the intersection. Plaintiff testified that she first was in the intersection while my client was still approaching a stop sign on Paulding Avenue. So since both of those accounts were in her initial submissions, she failed to carry her prima facie burden. With respect to the photographs, they need to be viewed in light of the parties' conflicting testimony as to the moment of impact. My client testified that plaintiff struck her vehicle, stuck to it, and ultimately crashed into a pole. If I can draw the Court's attention to the photograph at page 54, you can clearly see that there are multiple scratches along the bottom side of the vehicle. They do not only show an impact to plaintiff's driver's side door. A jury should be able to look at that alongside the parties' conflicting testimony and determine who was in the intersection first, which is the primary issue of fact here. So because plaintiff didn't carry her prima facie burden in the first instance, no burden shifted to us, but even if it did, as Justice Friedman iterated previously, our expert raised issues of fact in the alternative as to whether or not plaintiff was readily observable.
How do you address counsel's statement that your expert's opinion shouldn't be considered because it took into account material which he should not have done, which he should not have considered?
Well, assuming that we need to get there, if plaintiff carried her prima facie burden, I would say...
No, I understand that, but assuming that you got there, what do you say to counsel's statement that your expert's testimony shouldn't be considered because your expert relied on information that was improper?
I would say that all of those objections go to the weight of evidence, not admissibility. I mean, Mr. Scott sets forth his qualifications in his affidavit. He sets forth the foundation for his conclusions. He discusses at length what he did to ascertain the variables that he input into the EDSMAC 4 program. If you look, for example, at pages 1005 through 1011 and 1019 of the record, his foundation is adequately set forth. So I would say all of that, to the extent that's even necessary here, goes to the weight of the evidence, not admissibility. Finally, we raise an additional argument with respect to plaintiff's claims against the city. Fountain versus Ferrara, which we cite in our brief, states that factual allegations contained in a verified bill of particulars may be considered in opposition to summary judgment. One of those claims in plaintiff's verified bill of particulars is that, quote, operators on Paulding Avenue are unable to see approaching traffic on Burke Avenue. So that raises an issue of fact, in our view, as to whether or not this accident was truly unavoidable. But in any event, the court need not get there because plaintiff didn't carry her prima facie burden given the conflicting accounts of the accident. If there are no further questions, we're happy to rest on our briefs.
Thank you.
Just to address the argument that it should go to the weight, not the admissibility. Romano v. Stanley, Court of Appeals, that's 90 New York 2nd 444, Court of Appeals 1997, says the opposite. If an expert, even in opposition to summary judgment, expert report or affidavit relies on outside material as opposed to his own judgment or expertise or work, it's only deemed sufficiently probative if it's of the kind accepted in the profession as reliable, informing a professional opinion, and such reference is accompanied by evidence establishing the out-of-court material's reliability. There's absolutely nothing in this record that says that the computer program is something that's used by the profession or that it's reliable even. Absolutely nothing in the record that says that. That's Romano v. Stanley. It's a Court of Appeals case that stands for the proposition that if we're lacking that evidentiary foundation, it's not admissible. It's not that it goes to the weight or anything like that. It's just not admissible. And I cited in my briefs, I think 2 more Court of Appeals cases and a First Department case where an expert affidavit that lacked that evidentiary foundation necessary for the outside material, like a computer program, rejected the expert affidavits. Again, it doesn't go to weight, it doesn't go to the weight, it's rejected. And just to counter my colleague's point that Mercer testified that she was in the intersection for seconds. When she was asked, was it 1 second, 2 seconds more, she testified, I don't know, but when I looked, she was right on me. So again, it's not that there was seconds before she saw the plaintiff, it's when she saw the plaintiff, the impact had already occurred. And she also testified that plaintiff was already in the intersection right on her when the impact occurred. So if that's Mercer's testimony, she didn't see plaintiff until the impact. How can we extrapolate that she didn't see the plaintiff until the impact? How can we extrapolate from that to get to Mercer being in the intersection first? We can't without speculation. It would be impossible. She didn't see plaintiff. That means she can't give us any information about the 2 vehicles' respective positions relative to each other in the intersection, which would be necessary to deny summary judgment in favor of the plaintiff in this case.
Thank you.
Thank you.
Thank you both.